Good morning and welcome to the Bracewell Client webinar on disability law developments in 2018, what employers need to know. The presenters today at the webinar will be Jim Kizziar in the San Antonio and Washington, D.C. offices, and Chris Jaynes from the Dallas office. We have a lot to do today, a lot of information to relay, so let's get started. Let's talk first about the scope of this webinar. There have been many ADA developments in 2018. We're going to focus on four important issues. First, establishing and modifying essential job functions. This is an employer's responsibility, but it will come back to haunt employers in discrimination claims and lawsuits if not done effectively and properly, and if job descriptions and essential functions are not maintained current and effective. Second, developments in reasonable accommodations. Reasonable accommodations is the key issue under the ADA since the recent amendments. And there are always significant areas where employers can improve their performance and minimize the risk of claims under the ADA. Third, bringing FIDO to work. Service and comfort animals in the workplace. This is an area of both concern as requests for service animals increase, and a lot of uncertainty by employers. We hope to clarify some of that today. And fourth, preventing breakdowns in the interactive process. This is very important for employers because the interactive process is the key by which they determine exactly what an applicant or employee is asking for as an accommodation, discussing and reviewing issues relating to that request, and determining what's appropriate and what may not be appropriate as an undue hardship. Let's first talk about establishing and modifying essential job functions. Well, the first question is, what's a qualified individual with a disability? An individual with a disability is qualified if they meet the non-disability prerequisites for the position. And this includes education, experience, skills, licenses, and other job requirements. If they don't meet these non-disability prerequisites, there is no need to address whether they must be accommodated or not, because they can be disqualified for the job or, if necessary, removed from the job because they don't meet the non-disability prerequisites. Second, can they perform the essential job functions of the position either with accommodation or without the necessity for accommodation? Now, whenever you're making an analysis regarding whether someone is qualified for a job, it is a two-step process. Non-disability prerequisites first, performance with or without accommodation second. That analysis has to be made at the time of the employment decision, whether it be hire, transfer, promotion, or other. It has to be only a present time analysis. There may be individuals who have debilitating conditions, which will, with everyone's knowledge, get worse as time progresses. But the analysis that you're making about their present qualification cannot consider future changes in their condition and whether the individual may be unqualified in the future. Employers sometimes get very concerned that even the employee admits that within 2 to 3 years, they'll be unable to perform the job. That should not prevent you, and it certainly won't give you a legal shield to refuse to put the person into the job at that time because they'll become less qualified or unqualified in the future. In addition, if accommodations or other changes that might be necessary, or even just the hiring of the individual as an applicant would increase health insurance premiums or costs, or workers' compensation costs, those are employer responsibilities and cannot be considerations in deciding whether someone is qualified. So, what are essential job functions? They're the fundamental job duties of the position that the individual with the disability either holds or desires. Seems simple, but it's really not so simple in reality. There are certain criteria to consider in determining if a task or a function is essential or marginal. Now, let me just clarify one thing. Marginal doesn't mean it's unimportant. Marginal doesn't mean that it can be excused for non-performance. It's just a different classification from essential. The employee or the applicant need only be able to perform the essential job functions of the position with or without accommodation. And so it is much more frequent that marginal job duties are modified, transferred, or excused, while essential job duties must always be performed even with accommodation. So what are these criteria? Well, first, the reason that the position exists is to perform that function. If I'm going to be a bank teller, I need to be able to perform those teller responsibilities, to exchange money, to cash checks, to interact with bank customers. If I'm a drill press operator in a manufacturing facility, got to be able to operate that press. I might be able to operate it sitting down or standing up, or with other modifications in how that function is performed, but that is a critical function because my job exists to pull that lever and operate that drill press. Second, are there a limited number of employees who can perform that function? Where you have someone who is unique, they're the only person who can perform that function, then clearly that becomes much more essential. If that function is performed by a large number of people and is much more generic, perhaps it will be essential to every job, or perhaps less essential and more marginal. Third, is the function highly specialized? And the incumbent is either hired or selected for that job precisely for their ability to perform that function. There are some functions of a job that are frankly more important than others. Every job has a priority in the functions that need to be performed. And if something is highly specialized, its priority rises almost certainly to the top. Functions that are more likely are marginal, are not related to core duties, or maybe tasks that are performed that are ancillary to or before or after the core duties. Let's talk about our drill press operator. He has to punch that metal every day, every hour in precisely the same way. But does he have to go get the materials that he's going to work on, or then move those materials to the next workstation? Those are ancillary tasks, and those are much more likely to be considered marginal, perhaps, or much more easily accommodated if he has, for example, a lifting problem and can't do that kind of work.
After working our way through the definition of essential functions, we want to work through which evidence can support functions as being essential. There are several different ways to establish this. The most important, according to court decisions we've analyzed, is the employer's own judgment. The employer has the right to define the job he needs done. You need to express this in a variety of ways, including, importantly, the written job descriptions. You also want to consider the amount of work time spent performing the function under consideration. You can express this as a fraction of the total work time. You also want to consider the consequences of not requiring the employee to perform the function. Think about the business consequences if this task remains undone. What happens to your business goals?
You know, Chris, that's a great point on not performing the function. This is vitally important with safety functions and with security functions. Most police officers never take their gun out of their holster, but they have to have the ability to do that. And what's the consequence of that individual not being able to defend himself in that circumstance? Great point.
Exactly, and that's a theme we'll return to later, infrequently performed essential functions. Some other categories you want to consider are the terms of any collective bargaining agreement in place, and the work experience of past employees in this position you're considering, and the work experience of the employee currently in the position, and what they've done in prior roles. We want to walk through a few cases to illustrate the concepts we've been describing. The first deals with job descriptions. The case Mosby Meacham involved an attorney who had pregnancy complications, and she sought a reasonable accommodation from her employer. She wanted to telework from home for approximately 10 weeks. The employer declined the request because they considered in-person presence an essential job function. The employer relied on the job description to make this assertion. However, the court ultimately ruled for the employee. Why? Well, although the employer relied on a job description, the job description was significantly out of date as it relied upon 20-year-old job description surveys, and frankly did not account for advances in technology that made working from home much more reasonable. Furthermore, the employee presented conflicting testimony. She demonstrated testimony, her own, that said she had never performed the in-person job functions the employer was asserting were essential. The court also ruled that the temporary nature of the employee's request made the request reasonable. The lessons we can take away from this are that you should always keep your job descriptions up to date. Try to update them every 2 years or when the employee in the role changes. Furthermore, ensure that the actual duties the employee performs match the job description, and include on the job description essential elements that may not be as obvious. For example, the ability to work rotating shifts, the ability to work on site, and the ability to travel or respond at short notice, to come into the office at short notice or at weird hours. If that's truly essential to the job, make sure that gets into the description itself. Another case we'd like to discuss, which sort of came out the opposite way from Mosby Meacham, is Mielnicki out of the 10th Circuit. This involved an intellectually disabled Walmart employee. For years, Walmart never asked her to clean the bathrooms, although this always remained part of her job description, and others in her position were asked to clean the bathrooms. Finally, years down the road, a short-staffed situation led the management to ask this employee to clean the restrooms. The employee declined to do so, and when pressed on the issue, cited her anxiety. She did not want to enter the men's restroom alone. Walmart placed her on leave and did not grant a reasonable accommodation. In the courts, Walmart won on the ADA issue because the employee was asked to perform an essential function. Although the essential function, cleaning the bathrooms, was infrequently done, or in this employee's case, not done for years, it remained essential. And the takeaways from this are that Walmart kept their job descriptions up to date. They were able to prove that this remained an essential function despite being infrequently done. And one thing that's important we consider that the court said was that going beyond what the ADA requires cannot be used down the road to punish an employer. Just because the employer refrained from asking the employee to do this essential function did not make it any less essential. We can contrast this to Mosby Meacham, where it was debatable whether or not in-person presence was an essential function. But as a practical tip to avoid fights, always try to give the employee advance notice of changes, whether you're reasserting the need to do an essential function for the first time in a while, or you're changing what essential functions are required. Great. So one final case we want to discuss in all this is the case Stevens v. Rite Aid Corporation. Now, this is an example of an employer adding an essential function while you have an incumbent employee in the role. In this specific instance, the employer revised the pharmacist's job description to require that the pharmacist in the position now give immunization shots. This required a valid certificate and shot training. The pharmacist in the role had trianophobia, not to be confused with tyrannophobia, fear of dinosaurs. This is fear of needles. And the pharmacist sought and was denied the accommodations of, one, being excused from training to provide these shots, and being excused from giving the shots. It ends up in litigation, and the pharmacist won a $2 million jury verdict. However, this verdict was overturned at the Second Circuit, and the employer won. The court ended up giving considerable deference to the employer's judgment on what constituted essential functions. This included the employer's power to add essential functions, and essential functions can be changed even if the incumbent in the role has a disability that conflicts with the essential function you're adding. This is so the employee asked for other pharmacists to be the ones to give the shot, but this would have involved reassignment of essential job functions. This is an inherently unreasonable request because it places a higher burden on other employees. You can reassign marginal functions, but to reassign essential functions essentially means the employee is not qualified to do the task, and the request is unreasonable. Some practice tips we can take away from this case: you always want to confer with the employee before you're considering adding an essential function, and be sure to explain your reasoning. What are the business reasons to add this essential function to the task? Next, within reason, try to offer necessary training to become qualified. You can consider costs and time expenses, but if it's a reasonable accommodation, that may be something you wish to consider. In a neutral manner, you also want to ask the employee whether they have any issues with the essential functions you're proposing, If they assert an inability to do the task, try to determine if that inability is based on a non-obvious disability, and then the interactive process and the reasonable accommodation dialogue can begin. Remember, you always have the right to obtain medical documentation supporting a disability. If a disability does exist, try to determine whether a reasonable accommodation is feasible and easily implemented. This is the best way to avoid a fight. And always remember that elimination of an essential function, or in this case, refraining from adding a new essential function, is never a required reasonable accommodation.
Let's move to some recent developments regarding reasonable accommodations. As a refresher, what's a reasonable accommodation? There are modifications or adjustments to how work is done, or even what work is done, to provide applicants with access to the application and the hiring process that alters the work environment or the work process that is performed by employees and provides employees with equal benefits and privileges of employment. That's one that employers don't think about very often. But for example, if you have a mobility impaired employee and you hold your holiday party, since the holidays are up and coming, in the third floor or second floor of a building without an elevator, you've denied that disabled or wheelchair-bound employee perhaps the ability to participate in that company function. So be aware that it's not just the job, but the ancillary parts of being an employee that individuals get to participate in as well. Again, any kind of accommodation analysis and interactive process must be consider only the present time condition of the individual and be individualized. One of the key factors of the ADA and the accommodation process is that it must be individualized. You can't have a simple cookie cutter approach where you say, we do this, but we do no more. This is all we can do, because it may be reasonable to do a little more for this particular individual based on his or her circumstances. There are many, many decisions about reasonable accommodations. In the post-ADA amendment era, this is frankly where the rubber meets the road. This is where employers are oftentimes attacked most. And so we're going to focus on three key issues: accommodation of pregnancy and related conditions, disabilities, reassignment and transfer of an individual who can no longer perform their current position, the duties of their current position, to another job as a reasonable accommodation, and when the leave of absence process has reached its end and either the individual has completed their leaves required by law or granted by company policy, but they need more time to recover from their disabling condition and return to work, what are their rights and what are your obligations for extension of leave?
Wonderful. So as Jim just mentioned, the first topic we're going to dive into in detail is accommodating pregnancy and related disabilities. Now remember, the ADA itself does not treat pregnancy as a disability. It's actually the pregnancy-related impairments that may qualify as disabilities. And there are three ways in which they may qualify. First, the pregnancy-related impairment limits a major life activity. Second, there is a record of pregnancy-related impairment. Or third, the pregnant individual is regarded as having a physical or mental impairment. Now, these latter two categories are more for discrimination claims. The first category is more related to reasonable accommodations. Consider how a pregnancy-related impairment may arise, and I'm sure we all have examples in our own lives, whether it be bed rest, lifting restrictions, standing restrictions, or the variety of impairments that may come up during a pregnancy. A few examples of reasonable accommodations we have seen involving pregnancy-related impairments are as follows. You may be redistributing marginal functions. Contrast this with essential functions. An example of a marginal function may be if there is a infrequent unloading of merchandise, say, that comes in once a month. That is a task that can be reassigned to a non-pregnant employee. You may also consider altering how essential function is performed. If an employee typically types notes, consider whether dictating those notes is a reasonable accommodation. You may always modify workplace policies. For example, you may want to relax on a no food and no water policy at employee workstations if that is a reasonable accommodation. You may want to consider low cost or reasonable cost purchases or modifications of equipment or devices. For example, if the position requires a lot of standing, consider whether a stool is a reasonable accommodation. It's not always a complicated process. Sometimes it's as simple as providing a chair. You also want to consider modifying work schedules. Try to work around counseling appointments and doctor's appointments. You always want to consider whether leave is a reasonable accommodation, in particular, whether more unpaid leave is a reasonable accommodation. And then furthermore, related to my first point, always consider whether temporary assignment to a light duty position would be a reasonable accommodation. You always want to remain cautious strictly applying neutral leave policies. If you have an absence control policy that sets a specific time limit at which point adverse consequences befall the employee, and you strictly apply that to pregnant individuals with pregnancy-related impairments without considering the individual circumstances, you run a significant risk.
You know, Chris, that's a great point, because sometimes there's an inadvertent discrimination that occurs when individuals with a broken leg, individuals with non-pregnancy related conditions or disabilities are given leave extensions, but yet, for whatever reason, there seems to be this reluctance to give extensions when dealing with pregnancy. You've got to be careful about what you do with males, or even what you do with females who have non-pregnancy related disability conditions where they're given an extension of leave. A great way to overcome any kind of inconsistencies here is to keep an extension log. That way, when you give an extension, it's logged in, and you'll be able to identify who those people were, what was the reason for it, and it will minimize the risk of having an inconsistent action for pregnant.
That's a great point, Jim. I think we'll dive into more detail later about extensions of leave, and that log is crucial to determine whether extensions are reasonable, because you always want to look at the cumulative length of the extension of leave. And so when we're dealing with pregnant individuals with pregnancy-related impairments, you always want to consider whether further leave might be a reasonable accommodation despite your workplace policies, and you always want to remain cautious of a neutral application of a company-wide policy of refusing extensions. Now, an example we've been focusing on is the EEOC v. Allsup's Convenience Stores. This was a lawsuit brought by the EEOC against Allsup's, and they eventually reached a settlement just shy of $1 million with the convenience store chain. The EEOC alleged that Allsup's was committing a variety of pregnancy-related discrimination, including verbal harassment, unequal working restrictions, and failures to accommodate, including requests for lifting restrictions and requests for extensions of leave. And they alleged that Allsup's was applying this neutral leave policy in a way that didn't account for individualized circumstances and were routinely firing employees upon the expiration of medical leave. The lesson here is that they were failing to be flexible and consider individual circumstances.
You know, Chris, that's a great point, because one of the issues in the EEOC's 5-year compliance program is dealing with inflexible leaves of absence. And that inflexibility it was the $1 million problem for Allsup's here, and it was a solvable problem in advance by making the analysis of flexibility always a part of the end of your leave of absence for every employee. Well, let's talk a little bit about what boundaries there are on employer obligations for reassignment and transfer as a reasonable accommodation. The scenario is that Sally Superior has always done her job well. She develops a medical condition that prevents her from performing the job. She's smart enough and experienced enough to know that eventually she's going to get dismissed for failure to perform her job. So she comes to you and says, I need to be transferred to a different job because I can no longer perform the tasks of this one. What do? Well, let's look first at what the EEOC guidance is on reassignment. Now remember that guidance is just that. It's the EEOC's position on what employers ought to do. Sometimes the EEOC is a little over the top, sometimes they're way over the top, but oftentimes they do give good advice in their guidance. These are not regulations. but they're good things to consider. First, the employee has to be qualified for the position that they're seeking or the position that is offered. Again, those non-disability elements of skills, experience, education, etc. Can the employee perform the essential functions of that job, either without accommodations at all or with accommodations? Even when someone is being transferred as an accommodation, it may be necessary for the employer to accommodate the performance of the new job that the person is seeking. Now, you have no obligation to assist the employee to become qualified. Even the EEOC says that. If they say, I want to move into the legal department, there's no obligation to send them to law school. But you are required to provide the same training given or orientations given to any other applicant or transferee into the positions. The key of this is that the reassignment should be and must be the accommodation of last resort. The goal is always to have accommodations which are reasonable, which allow the individual to stay in their position. And so reassignment is only the last resort. In addition, you're not required to create a position. Positions must be vacant, meaning currently or in the reasonable amount of time. Well, what's reasonable? The EEOC and the courts differ here, and this is really a case-by-case determination, but even the EEOC has said that 6 months in the future for a position becoming available is too long, and that 1 month in the future is certainly to be considered currently vacant. If possible, the position to which the person is assigned should be equivalent in terms of pay and benefits, but if not equivalent, and you place the individual in a lower level position, there is no need to maintain the salary or the benefits at the prior level if this is anticipated in being a permanent change. A great example of this is an employee who can no longer work full-time and moves into an alternate position, which is part-time. That may affect their eligibility for medical or vacation or other benefits. So long as this is not a temporary accommodation where the individual is expected to move back to their job and you're relying upon medical documentation that said, this is it, it's a lifetime limitation, then you can modify those benefits when the individual is moved into the job. However, to avoid an angry employee, always make sure that you discuss that since this is a permanent condition and will be a change that is anticipated to continue, that benefit or other changes will occur, so the individual is not shocked and surprised in their first paycheck. Another factor that the EEOC points to and has been generally supported by court decisions is that reassignment cannot be limited by artificial geographic or employer transfer policies. If you have 6 divisions in your company and you only allow people under policy to seek a transfer within their own division or within the state or the geographic region, those limitations cannot be imposed to restrict that reassignment. Remember, if the reassignment involves relocation to a different facility, state, or even country, because it is a reasonable accommodation request and not an employer-directed transfer, the policies regarding reassignment, payment of reassignment costs, and financial support for the employees typically are not required to be applied as a reasonable accommodation. So there's 3 key issues regarding reassignment. Must a qualified disabled employee compete for a vacant position with others? Or, put another way, is the employee entitled to reassignment to a vacant position for which he or she is at least minimally qualified where there are other better qualified candidates? Second, what are the employer's obligations to assist the employee in identifying, applying for, and interviewing for vacant positions? And third, must the employer give an automatic preference to a qualified disabled employee over other qualified candidates for the position? The EEOC position on preference is that a competitive reassignment process that a disabled employee is required to engage in to obtain the accommodation of reassignment is simply not reassignment at all, but treating the disabled employee the same as other non-disabled employees. So the bottom line is that the EEOC, in considering reassignment issues in, say, discrimination charges or in lawsuits brought by the Commission itself, will always take the position that the disabled employee need not be the best qualified individual for the position in order for the employer to have an obligation to reassign that employee as a reasonable accommodation. The qualified individual only needs to be minimally qualified. Well, even under the EEOC's position, there are some limits. The employee must have all of the qualifications for the position, including those non-disability qualifications. You are not required to give an employee a promotion as part of a reassignment process. It's only at the same level or below. And employees must, in fact, compete to be reassigned to vacant positions that would constitute a promotion. So the employer's dilemma regarding reassignment and its obligation to give a preference or not give a preference to disabled employees is illustrated by this map. This shows the United States divided into three colors. The red color is where the circuit courts, the 7th, the 10th, and the DC Circuit, have required that an employer give a preference to a disabled individual who's seeking reassignment. If they're minimally qualified, the courts say the individual should be given the reassignment even if better qualified individuals have also applied. The areas in green, court decisions suggest, but are not necessarily absolutely confirmed, that no preference obligation exists. And this includes our own 5th Circuit that governs Texas, as well as the 2nd, the 4th, the 6th, the 8th, and the 11th Circuits. And there are some places where there's, at this point, just no direct circuit court case authority on whether preference is required or not. And that's the 1st, the 3rd, and the 9th Circuits. So what does this mean? What does this map tell us? Geography matters. Employers must know their circuit court positions and regularly update that on whether preference is required for reassignment accommodations. This is particularly difficult for multi-state employers or national employers because they may decide to have different obligations based on court decisions in different locations, or they may elect to simply provide a preference in this area across the board for consistency and reduction of risk. So let's talk about some recommended steps and tips for the reassignment process. We have looked at all of the cases, recent and older, on reassignment and tried to distill their lessons into these points. First of all, use a consistent process for reassignment of employees to alternate positions that is both documented, administratively workable, and is conducted through the right level of your staff. This is not an issue for supervisors to be making decisions. They typically just don't have the disability level of disability information needed. This is typically a human resources with sometimes legal involvement in making these decisions. Next, and very important, to determine whether the employee is in a preference jurisdiction. This should be updated regularly to make sure that you're not making decisions based on old law, but current law in the area involved. And just as importantly, determine if there's any other accommodation that will allow the employee to perform their essential functions of their current job and stay in their job. Remember, reassignment is the accommodation of last resort. An easy example is the cash register person in your cafeteria who has to stand. They develop back problems. They ask for reassignment. Let's give them what, Chris?
Stool.
A stool, right. And with that stool, that individual is going to be able to sit, take pressure off their back, perform their job. No reassignment issue is needed at all. When a person requests reassignment, they're typically at the point where they're unable to perform some or all of their essential functions. It is appropriate to place that person on a paid or unpaid temporary medical leave or FMLA leave, or to allow explicitly documented in writing temporary work limitations, temporarily perhaps excusing an essential function while the interactive process occurs and before the reassignment decision is made. Reassignment takes time, and the employee may need temporary accommodations during that period. The refusal to provide those temporary accommodations may itself be deemed a failure of accommodation if it's later determined that they should be provided by the employer. Make sure that you have an open dialogue with the employee on limitations. For non-obvious conditions, you can require medical documentation. Make sure that you ask the employee to identify those positions in which they are interested and for which they believe they're qualified. It's important that you determine if there are vacant positions, either at the present or in the near future, that you provide a list of vacancies to the individual, and that you advise the employee that it is his or her responsibility to apply for those jobs. The employee should not be able to say back to you, I want to be considered for everything. And the burden on you is to weed out every job for which they're not qualified. Give the person a list, ask them to identify the positions for which they are qualified and which they're seeking. If they want to look at job descriptions, obviously provide them to them. You want to make sure that you set a reasonable time period for the individual to apply. Depending on the size of the company and the complexity involved and the number of positions, this need not be open-ended, but somewhere between 2 weeks and 4 weeks is probably sufficient. If the employee meets the basic prerequisites for the position that they apply for, determine whether the employee can perform the essential functions of that reassigned position with accommodations. If there are questions based upon the medical documentation you have, it would certainly be appropriate at that point to seek and obtain a fitness for duty certification from their physician in that situation. If the person is not qualified, either because they don't meet the prerequisites for the position or accommodations are not possible, notify the employee and give them a second bite of the apple. Allow them an extension of time, perhaps an additional 2 weeks, to look at and apply for other positions. If the employee is qualified and the employer is providing a preference, either voluntarily or on a mandatory basis, notify the employee of the reassignment and begin that transition. If you're not providing a preference and the individual is qualified, notify them that their application is being considered along with others. And again, if the individual is not selected for a particular position, it may be appropriate to at least give them one additional time to seek and apply for other positions. If the employee cannot be transferred, determine if they are eligible for FMLA or other medical-related leave before you ever consider termination of that employee. Since at this point they are unable to perform their current job for medical reasons and would qualify from leave, it is much better to dismiss someone from an expired leave from which they never can return than to eliminate leave as a step in your process.
The final category we want to discuss under this topic are extensions of leave. Extensions of leave may be considered reasonable accommodations if they are for a defined period. That means you have an expectation of when the employee may return to performing the essential functions of the position, and that length of time is reasonable and specific. Always remember that multiple extensions of definite duration may also be a reasonable accommodation. You should always consider the number of extensions that have been granted and the cumulative duration of those extensions. Always remember that prolonged leave may be reasonable or unreasonable. It depends on the specific set of circumstances surrounding the individual. However, indefinite leave is not a reasonable accommodation. When you're evaluating requests for extensions of leave, you want to consider the following factors. The request needs to be for a reasonable length of time, and it needs to be definite. Indefinite requests do not constitute reasonable requests. The medical evidence at the time should also be considered, and the medical evidence should support the idea that the employee will regularly attend after the stint of leave ends. You also want to always consider the duration of leave. This is the key factor in reasonableness analysis. A long-term leave may be medically necessary, but is not necessarily reasonable.
You know, one thing, Chris, that we should remind our audience is that a request for extension needs to be submitted before the leave expires. If my leave expired 2 weeks ago and now I come in and seek an extension of leave, it's overdue. And typically, in the absence of unusual circumstances, need not be considered by the employer.
That's a great point, Jim. Some further considerations we want to touch upon is, has the employee already received substantial leave in accordance with your company policy, the cumulative leave beyond the scope of the typical company policy, and has the employee demonstrated clear medical prospects and a timetable for return? Now remember that if a medical condition prevents the employee from ever returning or from returning within a reasonable period of time, extension of leave is not required. If an employee is giving you open-ended answers and indefinite answers about their timetable for return, seek clarification. Do not let the conversation end with something like, "I will return to work as soon as I am able." The employee has an obligation to provide you with a specific timetable, and it may be appropriate to have periodic updates on the employee's status and whether those earlier predictions were overly optimistic. Some recent developments we've seen in various circuit courts have been that multi-month extensions of leave, when an employee has already been granted leave, are being found as unreasonable. Specifically, the 7th and 11th Circuits have been active. I'll just run through a few examples we've seen. The 7th Circuit, in a case called Golden, a public safety officer asked for an additional 26 weeks of leave after a 16-week absence. That was found as unreasonable. The 11th Circuit in Phillips, a service technician asked for another 6 months of leave after an extended period of leave had already passed. The court found that was unreasonable. The 7th Circuit in Severson found a manual laborer seeking 2 to 3 months of additional leave after exhausting his 12 weeks of FMLA leave was additionally unreasonable. The 7th Circuit provided some great quotes in Severson. First, the ADA is an anti-discrimination statute, not a medical leave entitlement statute. And second, the term reasonable accommodation is expressly limited to those measures that will enable the employee to work. An employee who needs long-term medical leave cannot work and is thus not a qualified individual under the ADA. So we just want to close out this section with a few other examples of unreasonable leave requests. These are important to keep in the back of your mind at all times. First, requests for retroactive leniency. A case out of the 10th Circuit, DeWitt, involved a diabetic customer service representative. She began having issues with low blood sugar, which caused performance issues, including hanging up on customers. She was placed on a last chance plan. Essentially, she had 2 out of 3 strikes, but had further performance issues. She was brought in for a termination meeting, and in that meeting, for the first time, she blamed her performance issues on a disability, namely the low blood sugar drops resulting from her diabetes. The employer proceeded with termination, and this decision was ultimately upheld by the 10th Circuit. The 10th Circuit found that the ADA does not require an employer to excuse or overlook past misconduct. The obligation under the ADA for an employer is always prospective. The next case we want to talk about was a request for non-confrontational treatment. The case is Hargett v. Florida Atlantic University. In this case, the employee was experiencing seizures, which she attributed to tension and stress in the workplace. She described her supervisor as rough and harsh. The employee was granted by the employer the reasonable accommodations of daily breaks to compose herself and reduce her stress levels. However, the employee was denied a request that her supervisor receive sensitivity training and provide calm, fair, and non-confrontational treatment. The court held for the employer. The court held that although specific stressors can be legitimate targets of accommodation, it is unreasonable to request a change in management style, or immunization from all stress and criticism in the workplace. We can take away from this that no employee is entitled to a stress-free work environment as a reasonable accommodation, and reasonable accommodation measures must be requested to address specific actions and specific targets of stress, but an employee may not request generalized demand for a less stressful or no-stress work environment.
Let's take a moment and talk about service and comfort animals in the workplace under the ADA. First of all, I want to note that there's fairly little precedent on this issue for employment issues. Most of the precedent in this area is under Title III of the ADA, which is for public accommodations and people bringing service animals into, say, businesses, restaurants, hospitals, etc. That's where most of the law comes from. And so the things that we're talking about today are from the limited precedent under the employment title and the precedent in the public accommodations area. First, a service animal is a dog. It's not an iguana. It's not a ferret. It's not other wild or domesticated animals. And that service animal has been individually trained to do specific work or assist an individual with a disability. The services that are provided by the animal must be directly related to the person's disability. Now, this may include dogs that assist with psychiatric disabilities, such as anxiety or seizure disorders, if the dog performs a specific task, such as helping the individual, warning the individual, etc. Dogs without specific training are not considered service animals. Now, terminology in this area varies significantly. You have service animals, emotional support, therapy, comfort, and companion animals. Under the ADA's multiple titles, access of the general public to facilities grants certain protections only to service animals and not perhaps companion animals. However, under Title I, which governs employment relationships, there's really no distinction between service animals and comfort animals. And as the precedent expands in this area, those distinctions continue to blur. The appropriate analysis for any employer confronted with a FIDO in the workplace request is to determine whether the animal, be it service, comfort, or companion, is a reasonable accommodation for a specific disability. Some advice regarding accommodation requests for service and comfort animals. The request to use such an animal must be treated like any other reasonable accommodation request. It's critical here to only ask permissible questions and to avoid impermissible questions or artificial standards or hurdles to the applicant or employee. If it's a non-obvious condition, requesting medical documentation and support is certainly appropriate. And always consider whether there's an alternative accommodation that may be proposed back by the employer instead of bringing the animal into the workplace. What are some best practices in this area? Again, we've looked at all of the cases and tried to distill the recommendations and the problems that others have encountered into these suggestions. Number one, always set boundaries. Where is the person going to be allowed in the workplace? Are there food service, security, or sanitation limitations? Must the animal be leashed and controlled at all times? Address boundaries as part of the interactive process and before the accommodation is approved. Make sure that expectations are set out. Where will the animal relieve itself? Who will be responsible? The employee for taking the animal on these relief situations. How will noise and distraction be mitigated? Must, for example, the door always be closed? If a person works in an office, how do we control noise and distraction? How will co-employee interactions be limited? You want to absolutely avoid turning a service animal into an office pet. And continue communications while the accommodation is being provided. If the condition is not permanent, look at periodic medical updates to determine whether the animal is still required. It is certainly appropriate when there's a condition is temporary to give the accommodation for a period of time and to then reassess at that later point.
Great. Thank you, Jim. So we've talked about essential functions, we've talked about reasonable accommodations, and throughout these discussions, we've mentioned the interactive process. So let's dive into greater detail about what's required in the interactive process and what the employer and employee obligations are. Let's focus on the key elements of the interactive process from a management side perspective. First, you always want to provide clear guidance that's readily accessible to applicants and employees on how to request an accommodation. Consider that the way you provide guidance to employees and the means of providing that guidance might be different than applicants. Next, identify who within the company is going to manage this process. Someone needs to be directly responsible for coordinating and engaging in the interactive process, and importantly, who ensures that communications are ongoing and no communications are forgotten. Make sure that you're always timely communicating with applicants and employees. Usually, this is someone within your HR department. Next, communicate the obligations of the individuals who are seeking accommodations. Make sure they understand what's required of them to keep this process going. Always ensure that there are procedures in place so that any medically sensitive information that is communicated to you is kept confidential. You always want to notify the individual, be it an employee or an applicant, of their duty to cooperate in the interactive processes and the consequences of non-cooperation. Always provide prompt responses to accommodation requests and other communications from your applicants and employees. If you choose to decline an accommodation request, explain why the proposed request is an undue burden on the employer or ineffective to treat the disability in question. If feasible, try to brainstorm and offer alternative reasonable accommodation proposals. You don't want to be the first one to stop talking in this process. Always try to vet and think about every alternative reasonable accommodation. At the end of the process, you want to review the interactive processes transpired, review the communications, and consider whether you've eliminated the alternative accommodations before denying the request in full and ceasing communications.
Two additional points is that employers should keep an accommodation log. The log should include the date the accommodation request was received, who was designated as responsible party on behalf of the company, and then each step in that process and the date and the timing of that should be included on that log. It's not only a helpful document to keep you on track, but it allows you to demonstrate that you were very timely in how you did this. A second issue is that an employer should designate for each request a specific individual, say someone in human resources, to deal with the accommodation request. One of the most aggravating problems for applicants or employees seeking accommodations is to have their issue moved from person to person as the company representative. And if you have an ongoing accommodation that perhaps is related to a lifetime disability, that may naturally occur over periods of years, but moving them from person to person is not only aggravating, but creates the impression, certainly unintended, that this is of low priority and that really nobody wants to deal with it, and that's why it's being shuffled to someone else. So what are the employee responsibilities during the interactive process? Well, typically the employer's obligation to even engage in the process is triggered by an employee's accommodation request. There are no magic words. You will seldom hear people say, I need a reasonable accommodation under the Americans with Disabilities Act. They'll tell you, I have a problem. I can't do this. I'm no longer able to do that. I need your help. Accommodation requests can be made orally. You can ask them after the oral request is submitted to then put it in writing or in an email. Third parties, whether they be family members, rehabilitation agencies, they can make requests on behalf of employees. Employees typically should propose a specific accommodation. What is it that you want? But it won't necessarily occur at the beginning. All they know is they can't do something and they need help, oftentimes. And we're permitted for non-obvious conditions or where there's a conflict in the medical documentation provided by the employee, you can seek medical documentation yourself from the employee's physician with an emphasis on seeking functional work limitations and potential accommodations that the physician might recommend. There are times, however, when an employer needs to take the initiative, when the employer needs to act first, when the employee is not seeking an accommodation. The most famous case involving this was Walmart. A developmentally disabled employee was having problems at work. Walmart knew the employee was had a disability. Walmart knew, or in some other cases, the employer should have known, unless they were ignoring the issue, that the employee was experiencing workplace problems because of that disability. And third, Walmart either knew or should have known that the mental or emotional disability that this individual had prevented him from even coming forward and requesting a reasonable obligation. In that situation, the court found that Walmart was liable for failure to accommodate when it simply terminated the employee for poor performance instead of coming to him and saying, "Are you having problems in the workplace, and what can we do to help you?" These kind of situations where an employer must act first without an accommodation request are typically limited to mental and emotional conditions. If I may be physically disabled but mentally alert, I should be able to seek accommodations myself under the ADA. Now, a new issue has developed in the past year, which employers need to be very concerned about, and it's timing. An employer must engage in the interactive process and, if necessary, provide a reasonable accommodation. The EEOC and some courts have faulted employers for delays in the interactive process, either an overall delay of weeks or months, or a delay in a specific segment of the interactive process. So the factors that are being considered by the courts: what was the reason for the delay? Was it from the employee or the employer? What was the length of the delay? How much the individual with the disability and the employer each contributed to the delay? Who was at fault? What was the employer doing during the delay? Was it continuing to seek information or just sitting back? Whether the required accommodation was simple, which could have been done immediately. Let's get you a stool and have you sit on that, at least on an interim basis. Or was it complex? And another key issue is, what did the employer do to provide temporary or interim accommodations while they figured out the problem and the permanent solution? Remember, each request for accommodation has to be analyzed separately. So saying that we had a huge number of requests or a high volume of requests is not going to be a defense against delay. This is increasingly a claim in EEOC charges in the courts. This is where your interactive process and accommodation log is extremely helpful, showing the dates and times of responses and making sure your team is trained to do that. We have completed the first part. We have one more section.
So we just wanted to discuss one example of a breakdown in the interactive process. The case is called Michelle G. v. Department of Treasury. This involved a technician who was responsible for examining tax returns, speaking with customers, processing transactions, and documenting resolutions of customer issues. She claimed attention deficit disorder. She provided medical certification stating she struggled with attention deficit disorder, concentration, poor memory, disorganization, anxiety, and a variety of other symptoms, but she claimed she could perform her duties with a reasonable accommodation. The employer granted her a separate workspace, which succeeded in alleviating some of these performance issues for a time. But later, when the office relocated, she was placed again in close proximity to her peers, and her performance deteriorated. The employer engaged in the interactive process again, but took no accommodation actions. They rejected all requests for a variety of reasons. Each accommodation request was delayed, and the court ultimately found that the employer's delay was so great that they incurred liability. This is because the employer had already demonstrated a reasonable accommodation was possible, moving the employer farther from other employees. But this delay ultimately harmed the employer when they wouldn't make the same reasonable accommodation again. The EEOC determined that the unnecessary delay was discriminatory.
We have time for just one question, and it was a great question regarding our FIDO at Work section. There have been situations where an employee is terrified of dogs and where an accommodation is given to another employee to bring their service animal into the workplace, that terrified employee refuses to come to work or insists on their own accommodation of remote work. How do you handle that? Well, here's the classic example of perhaps competing needs. If an individual establishes that a service dog is appropriate in the workplace and you provide that accommodation, you must also consider whether giving that accommodation results in a problem for others. The impact on other employees is a key issue in determining whether any accommodation is reasonable. In this situation, I can think of several options. Number one, if feasible, separate the employees so that the one employee does not interact with the other. Second, if you have like a general cafeteria and the employees will be going to lunch, ask the employee who has a fear of animals when they'll be eating, ask them to eat on a consistent schedule, and then ask the other employee with the service animal to eat on a different schedule so there's no interaction. If you can't keep them apart in a reasonable manner, including perhaps an offer to change to an alternative work shift or alternative work schedule or even alternative building, then look at whether remote work in whole or in part is an acceptable accommodation. That's a dilemma. We may not have all the answers, but that's a start to help you in the process. We've completed our webinar. We thank you for attending. We wish each of you a very happy and safe holiday. And after we've given you this holiday break, we're going to resume with webinars in 2019 on developments in the law in that year. Best wishes to you all, and we'll conclude our webinar at this time.